note the three dates. Well, it's the post-coalition through opposition government came on 26 July 19. Just note the three dates. Whereas there was in between small coalition period. Then whereas the government of the current central government ruling party came on 26 July 2019.
Huh.
Well, it's the official principal secretary level decision to say that MUDA will take a decision at their level, entirely delegating to MUDA, is published on 14/11/19. That is 5 months after the BJP government had come.
All right.
14/11/19. And finally, the MUDA acting under that government mandate of a different government on 20th November 2020 decided to give 50% of the developed area as compensation. Wherever MUDA has not acquired land or not proceeded to acquire fully.
Not acquired, but utilized.
So therefore, Manas, these are the three crucial dates. Of course, one of my learned friends here on the other side have gone to the extent of saying, and I have no illusions about myself, but well, she certainly has illusions about me, that I was so powerful even as the opposition that I engineered this. I am very happy for the compliment, Wallace, but I'd rather live without such left-handed compliment because I have no illusion about my own power. But Wallace, anyway, these three dates are crucial because the operative thing is happening 5 months after the new government and 7 months Wallace, at the end of 2020. 1 year after that first. So decisions are 14/11 and 2011-2020 next year.
Yes.
So Wallace, this is when all this has happened. And without that consummation, there would be no such complaint. That entire consummation, the actual so-called, if I may say, Wallace, the fruits of crime, I mean, I'm not saying crime, but have happened entirely during a BJP government.
While you were in the opposition.
Very, very deeply obliged for a very patient hearing.
Yes, yes.
So, good my lords, excuse my absence. My friend may
Yes,
add
yes,
something.
no problem. Yes.
Very deeply obliged.
Yes.
After the argument started, a sheaf of papers are given before the court saying that they are the proceedings of the government,
What papers?
records of the governor.
ಈಗ.
ಅಲ್ಲಿ ಕೊಟ್ರಲ್ಲ ಆಗ್ಲೇ. That
The other day. Yes, yes. All right.
may I request the court to kindly take those
Yes.
papers for a minute.
ಗವರ್ನರ್ ಕೊಡಿ. ಅವ್ರ ಇದ್ರಲ್ಲಿದೆ. R2 ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡಿ. Take this. ಸರ್ ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಾರೆ ಮೆಮೋನಾ?
No, governor's file.
ಗವರ್ನರ್ಸ್ ಫೈಲ್ ಇಲ್ಲ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ನೀವು ಓದಿ ಇದ್ರಲ್ಲಿದೆ. ಎಸ್ ಸರ್. ಇಲ್ಲೇ ಇದೆ. ಎಸ್.
Sir, kindly come to page 3.
Yes.
Paragraph 8.
Yes. Yes, sir.
This is the first order passed by His Excellency, the Governor. I have heard Sri T.J. Abraham
Yes.
in person,
Hmm.
gone through the petition and supporting documents submitted by him. Prima facie, I am of the view there might be irregularities and misuse of power. Kindly mark the words.
Yes, there may be.
There may be irregularities and misuse of power. Hence, issue show cause notice to Sri Siddaramaiah. I'll refer to the show cause notice, what it is. So
Yes.
this is the first signature in the file
Yes,
on 26/7.
yes,
Now kindly come to the next signature. Page 5,
Hmm.
same day.
Hmm.
This is to send the notice.
yes,
Draft copy was approved. It is being sent. Then, as per the orders of the Honorable Governor, draft copy of the letter again same it repeated.
Hmm.
Page 7.
Hmm.
So this
Yes.
is the first sign of application of mine. Put up along with comparative statements of petitions.
Yes, because there were other complaints.
Comparative statements of petitions, Chief Minister's reply, and cabinet decision.
Yes,
So this is the first direction.
yes,
Now thereafterwards, His Excellency passes another order on 14/8.
yes,
Peruse the file,
yes.
discuss the issues,
Hmm.
hence resubmit the file along with notes, analysis, points as dictated based on the comparative statement and available documents and petition. So this is on 14/8. Now thereafterwards, the final order comes. So these are the only deliberations of His Excellency. Now what I want to show is, kindly come to para 25. Now this is a file built up on the representation of or the application of Mr. T.J. Abraham,
Yes, Abraham.
which was filed on 26/7.
Yes,
Kindly come to page 9.
all right.
There is a reference to 3 petitions.
Yes,
Item number 3 is a petition from Snehamayi Krishna,
that is the fourth respondent.
dated 5/7.
Hmm.
I want to know where is that file? Why it is not placed before the court?
So it is in the original file.
No,
Not
it
there
has,
in the original file. All right, yes.
anyway, it is not given to us.
No, original file is not given, only the.
ಅಲ್ಲಲ್ಲ
office-
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. No, what I want to tell the court is, ಅಷ್ಟು ಪ್ರೀತಿಯಿಂದ ಅಬ್ರಹಾಂ ಕರೆದು ಕುಂಡ್ರಿಸ್ಕೊಂಡು 90 ನಿಮಿಷ ಮಾತಾಡಿದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣನ್ ಪಾಡೇನಪ್ಪ ಅಂತ. ಅವ್ರನ್ನೇನಾದ್ರು ಕರೆದಿದ್ರ, ಅವ್ರನ್ನ ಮಾತಾಡಿದ್ರ, I think my learned she will not interfere with my submission.
All right, wait.
5/7/2024. That is the first application given. What is the deliberation of His Excellency on that petition? Is a file opened at all? If so, what are the orders passed? Why notice was not issued in that first petition that was filed before? So is the case with Pradeep Kumar,
The fifth respondent.
fifth respondent. So this is one issue which needs to be addressed. Now, be that as it may, kindly come to the order that was dictated
By the governor.
by the governor.
Yes,
That is what
yes.
the
that is
note
what-
says.
Yes.
Governor doesn't say this is the order. No, notes. We have to infer that this must be the order.
Dictated.
Dictated. Now, para 27 onwards
Is the dictation.
is the supposed dictation. Kindly come to. So the first one are all in the nature of preamble. What happened? Para 30 deals with Council of Ministers and the contents of the cabinet
Yes.
advice. I'll not trouble the court with the text of it because it only extracts what the cabinet has advised. Kindly come to para 31.
Hmm.
In view of the averments made in the aforementioned petitions, seeking grant of sanction for prosecution and the materials in support of the same, the subsequent issuance of show cause notice dated 26/7/2024,
Mhm.
reply to the show cause notice by Sri Siddaramaiah, Honorable Chief Minister, legal opinion of the learned Advocate General, and the decision of the Council of Ministers dated 1/8, I am of the opinion that in exercise of my powers under Article 163(1) of the Constitution of India, considering the aforesaid materials placed before me, and the facts and circumstances present of the present matter. As a matter of propriety, I shall exercise my discretion. So this is where His Excellency comes to the conclusion that he will exercise his own independent.
That is because he concludes that the decision of the cabinet, decision of the council of ministers is irrational.
No. Previous paragraph, there is no such thing. Court,
Allah, the order.
Allah, I bow down to Allah. We can't disjoint the order from the note.
Alright.
Order is a product of this. I will also demonstrate how it is a product of this very note.
Yes.
Because the order by itself does not contain any.
No, order does not contain, but the order does contain the words. I decided to exercise discretion on the score that the council of ministers decision is irrational.
If I may say so, the order is a very interesting order.
No, page 44 of the petition, the order says.
ಅಲ್ಲ ಅದನ್ನ I'll deal with it. ನನ್ಗೊಂದು ಕತೆ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ಒಬ್ಬ ಭಕ್ತ ಅವನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬೇಕು ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡಿ. ಈ ಡಿಸೈಡ್ಸ್ ಟು ಗೋ ಟು ಕೈಲಾಸ, ಶಿವನ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ. ಆ ಹರಿಗೆ ನಾನು ಪೂಜೆ ಮಾಡಿದ್ರೆ ನಾನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತೇನೆ ಅಂತ 2 ಲೋಲಾಕ್ ಕಟ್ಕೋತಾನೆ. ಕಟ್ಕೊಂಡಾಗ ಏನಾಗುತ್ತೆ, ಹರಿಗೆ ನಾನು ಯಾವ ಕಾರಣಕ್ಕೂ ಪೂಜೆ ಮಾಡಬಾರ್ದು, ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು. ಬಟ್ ಅವ್ನು ಎಡಗಡೆಗೆ ತಿರ್ಗುದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ, ಬಲ್ಗಡೆಗೆ ತಿರ್ಗುದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ. ಸತ್ತಾಗ ನೇರ ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ತಾನೆ. ನನ್ನನ್ನು ಯಾಕಪ್ಪ ಕರ್ಸ್ಕೊಂಡೆ, ನಾನು ನಿನ್ ಭಕ್ತ ಅಲ್ಲ, ಶಿವ ಭಕ್ತ ಅಂತಾನೆ. ನೀನ್ ಮಾಡಿದ್ದಿದೆ ತಪ್ಪು. ನೀನ್ ಪ್ರತಿ ಸಲ ಲೋಲಾಕ್ ತಾಕ್ತಾಗ್ಲು ನನ್ ಜ್ಞಾಪಿಸ್ಕೋತಿದ್ದೆ, ಶಿವನ್ ಜ್ಞಾಪಿಸ್ಕೊಳ್ಳಿಲ್ಲ. ದಟ್ ಇಸ್ ವಾಟ್ ದಿ ಗವರ್ನರ್ ಹ್ಯಾಸ್ ಡನ್. He is obsessed with the cabinet note. All right, he rejects the cabinet advice. After that, what has he done?
So that was the material before him in reply. So he has to look into it.
That he has not done.
That
For
here in
example,
the order is.
Chief Minister's reply is there. I will point out that also. Not a whisper in the entire order. Not a whisper in the order sheet.
No, the defense was that chief minister's reply, the cabinet note are verbatim similar. So one is taken into consideration.
We can reject.
Wait, Rangnath. Yes. Adalle irli. Yes.
No, cabinet.
No, that is the
No,
argument.
cabinet advice may be refused to be looked into. That he has said so. But he can't refuse to look into my reply.
No, the argument was there verbatim similar.
That order should say so. Your argument to. So argument ಹೇಳಿದ್ದಕ್ಕೆ
Yes.
may I request the court to kindly just one paragraph I'll show. Mohinder Singh.
All right, para 8, 851, 78, 851, para 8. Yes.
May I just read that? And the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise.
Statement of objections or otherwise.
Otherwise, an order bad in the beginning may,
Will get validated.
by the time it comes to the court, on account of a challenge, get validated by additional grounds.
The orders are not like old wine getting better by the day. Yes.
Govardhan Das Danji, quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, not even by the contesting. Even if the officer gives it, it can't be accepted. Making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders publicly made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine becoming better as they grow older. So that is what, so it has to be summarily rejected, whatever arguments or justifications are given. I'll come to the order later. Now kindly see, Now that the court says there is a reference to it, may it take the court to the impugned order. Volume 1. Volume 1 of the petition. ಅಲ್ಲ ಈಗ ಕೊಟ್ಟಿದ್ರು.
Same. Volume 1 of the petition.
Volume 1 ಅಲ್ಲಿ ಇದೆ.
Yes, sir.
Paragraph, page 41.
Yes.
Para 1 quotes the order.
Yes.
Para 2 quotes the two petitions given.
Para 3 show cause notice.
Para 3 show cause notice. Para 4
Committee.
council about the committee.
Yes.
Then para 5 the resolution of the
cabinet
cabinet
decision.
cabinet
Yes.
resolution. I have considered the decision of the cabinet dated 1/8. That is para 6. And file in relation to the issue at hand. It is noticed from the said file that Sri so and so had asked the chief secretary to convene a meeting of the cabinet and to place the show cause notice dated 26/7 and all other materials before the cabinet. Accordingly, the cabinet meeting was convened on 1/8/1918, wherein show cause notice dated 26/7 and other materials were discussed, and the aforesaid resolution dated 1/8/2024 came to be passed. I have also taken note of the fact that the said cabinet meeting was not presided over by Sri Siddaramaiah, the chief minister. So it only narrates what the cabinet has done. In the present case, the petitions have been filed seeking grant of sanction against Sri Siddaramaiah. The resolution dated 1/8 of the cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above, and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution against Sri Siddaramaiah, Chief Minister, I have also independently examined the petitions and documents submitted in support of the same, not the representation of the same.
Yes.
Now, since the sanction is sought against Chief Minister himself, the surrounding circumstances of placing the show cause notice and the decision of the cabinet would not inspire confidence to act on such advice. So it is about cabinet advice. Para 9. Subject of binding of the advice, again it quotes the cabinet this thing and quotes Madhya Pradesh police establishment case. That is it. Then para 10. This is where a decision is taken.
Upon perusal of the material.
Upon perusal of the petition, sir, not material.
Petition along with the material.
Along with materials in support of the allegations in the petition and subsequent reply of Siddaramaiah and advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It doesn't spell out what are those two versions. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of offences. Nearly 25 offences are cited. Which of those offences? For example, forgery is alleged. Is it the case that the governor is satisfied that chief minister has forged?
This is the first question I asked him the other day. Anyway,
Yes.
he will answer.
Yeah. So, my very respectful submission, this is not consideration of the representation. And the very interestingly, the note is important. That's why I was reading para 31 in the note. So this is all what the order says.
Order says, the governor's note is there.
Governor's note
Yes,
alle,
yes.
para 31 alle.
Yes, yes. You can read, yes, sir.
Yes.
Hmm.
In view of the averments made in the aforesaid petitions, seeking grant of sanction for prosecution and the materials in support of the same. Subsequent issues of show cause notice dated 26. Reply to the show cause notice of by Sri Siddaramaiah dated 3/8. Legal opinion of the learned Advocate General and the decision of the Council of Ministers. I am of the opinion. So considering all this, what is the opinion formed? I am of the opinion that in exercise of my powers under Article 163(1), considering the aforesaid material placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion by independently examining the aforesaid material. So he now proceeds to examine. What does he examine? 31.1. It is seen from the resolution of the Council of Ministers. The conclusion has been arrived at by the Council of Ministers by non-consideration of relevant material facts. For instance, the Council of Ministers has taken into consideration that absence of possession notification or a measure taking possession was mandatory.
Yes.
However, the revenue transfer certificate as provided under Annexure A5 of the petition by T.J. Abraham clearly stated possession of the alleged land was with MUDA. Further, the fact that the alleged land was developed, etc., I'll come to it later. So, Governor is satisfied, possession is with MUDA. Because Abraham says so, and cabinet advice to the contrary is rejected for that reason.
So documents are there.
I'm obliged.
His name is
I-
there everywhere.
I'm
That is what
deeply-
is said.
I'm deeply obliged for that. Kindly come to documents of Abraham.
R3 ಕೊಡಿ.
90 minutes governor has heard. I think this was the only pertinent question he should have asked. Kindly come to para 51.
Para 51.
Sorry, page 51. This is Abraham's petition. which sta-
Objections.
No, Abraham's application, sorry,
Complaint.
complaint, which starts at page annexure B, page 48.
Sorry.
I'm sorry. Gadbudi ಆಯ್ತು.
ಇಲ್ಲ, ಇಲ್ಲಿ file with. Page?
Page 48,
Yes.
annexure B.
No, you are referring to the complaint of T.J. Abraham.
Yes, R3.
That is found in which,
This is what the learned,
no, you're
The-
reading the
it's-
governor's note or the
no, governor's note refers to Abraham's content.
complaint? That is page 50?
Page 48, annexure B.
48 it starts, annexure B.
Ah.
Yes, sir.
Yes. Now kindly come to page 51.
Hmm. Yes.
Award declared,
Hmm.
page 51. On 30th March 1998, subsequent to the notification dated 20th August 1997,
Ah.
the preliminary award notice dated 20th August 1997,
Hmm.
the award decision notice dated 12/3,
Hmm.
and the final award notice indicating award of 3,24,000
Hmm.
was issued on 33 to Ninga, son of Javra.
Hmm.
Sir, Ninga is dead
Hmm.
28 years ago.
But the award notice refers to Ninga.
It is issued in his name.
Yes.
It is issued in name.
Hmm.
A copy of the preliminary award notice, the award decision, etc., are produced.
Hmm.
Then immediately, next sentence, he stumbles on this conclusion. Possession with MUDA.
Hmm.
As a consequence of the notification, the entries for the year 98-99 in the RTC
Hmm.
indicates that the said lands were in the ownership and possession of MUDA,
Hmm.
effectuated by so and so. Now the question is, when was the possession taken over by MUDA? He doesn't say so. Why he doesn't say so, I will refer to it. Kindly come to annexure B1.
No, possession was taken over by MUDA. No, he may say or is not said. But does the fact remain that possession was taken by MUDA after the preliminary notification, final notification, award notice, then MUDA is in possession. Everywhere it is said MUDA is in possession.
I'm obliged.
Symbolic or
Kindly come.
physical.
I'm obliged for that also.
Yes.
Kindly come to Annexure B1.
That's the annexures that were read out earlier.
Sir, this has been suppressed. I'll point out.
What has been suppressed?
The fact that possession was not taken.
Where is the document?
I'll show that. Kindly come to Annexure B3.
D3,
B3,
B3.
page 105. This is the crucial document. I request the court to kindly permit me to read.
Yes,
It's a very
please.
short document.
Yes, yes. Award notice.
This is award notice.
Yes,
Under section 12(2
yes,
of the Land Acquisition Act.
yes.
So everything is addressed. Ninga, as
Ninga.
court observed, it
Yes.
is Ninga Uruf Javra.
Hmm.
Property name is correctly described. No problem. Kindly come to the narrative at the bottom of the page. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಅವಾರ್ಡ್ ಆಗಿರುವ 3,24,700 ರೂಪಾಯಿ ನೀವು ಈ ಆಫೀಸಿಗೆ 15/4/98 ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ ಈ ಜಮೀನಿನ ದಾಖಲಾತಿಗಳ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿರತಕ್ಕ ದಾಖಲಾತಿಗಳು ಹಾಗೂ ಈ ಸ್ವತ್ತಿನ ತಹಲ್ವರೆಗಿನ 13 ವರ್ಷದ ಬಾಬ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮೇತ ಹಾಜರಾಗಿ ಮೊಬಲಗು ಪಡೆಯತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಪ್ರಾಧಿಕಾರದ ಕೆಲಸಗಳಿಗೆ ಬೇಕಾಗಿರುವುದರಿಂದ ಅದನ್ನು ಈ ನೋಟಿಸು ತಲುಪಿದ ಡ್ಯಾಶ್ ದಿನದೊಳಗಾಗಿ ಅದು ಕೂಡಲೇ ಇರಬೇಕು. ಐ ಡೋಂಟ್ ಗೆಟ್ ದಿ ಇಟ್ ಇಸ್
ತಲುಪಿದ ಕೂಡಲೇನೆ.
ಕೂಡಲೇ ಇರಬೇಕು.
ಎಸ್.
ಕೂಡಲೇ ದಿನದೊಳಗಾಗಿ ಖುಲಾಸು ಮಾಡಿ ಇಲಾಖೆ ಮಜುಕೂರಿಗೆ ಒಪ್ಪಿಸಿಕೊಡತಕ್ಕದ್ದು. ವೆಕೇಟ್ ಮಾಡಿ ಪೊಸೆಷನ್ ಸರೆಂಡರ್ ಮಾಡಿ ಅಂತ. ತಪ್ಪಿದಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಕಾಯ್ದೆ 16ನೇ ಸೆಕ್ಷನ್ ಮೇಲೆ ಸ್ವತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. ಸೊ ದಿಸ್ ಈಸ್ ದಿ ನೋಟಿಸ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹಿಮ್ ಟು ಸರೆಂಡರ್ ಪೊಸೆಷನ್. ಅಲ್ಲದೆ ಇತ್ತೀಚಿನ 3 ವರ್ಷಗಳ ಎಟ್ಸೆಟ್ರಾ ಅದೇನು ಬೇಡ. ಸೊ you surrender possession immediately. When was this served and on whom it was served? It was served on one son, Mallayya. It was served on 18/4/1998. 15/4 ಬಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಅಂತ ಕೊಡೋ ನೋಟಿಸು 18/4 ತಲುಪುತ್ತೆ.
4 days ಅಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅದೇ ಆ ಇವೆಂಟ್ ಆಗೋದ್ಮೇಲೆ, ಆ ಡೇಟ್ ಆಗೋದ್ಮೇಲೆ ತಲುಪುತ್ತೆ.
ಹಾಗೆ.
ಸೊ ಅವ್ನು ದುಡ್ಡು ತಕೊಳ್ಳೋದ್ ಸ್ಕೋಪ್ ಇರ್ಲಿಲ್ಲ 18/4. ಸೊ ಅವನು ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾನೆ ನಿಂಗ ಪಾವತಿ ಆಗಿರೋದ್ರಿಂದ ನಾ ತಗೊಳ್ತೇನೆ ಅಂತ. ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ಅದು ಬಿಫೋರ್ he was dispossessed, either he should have surrendered thereafter and there should have been a measure. Not a scrap of paper is produced by them to say that any such measure was conducted or possession was taken. Much less any details are given as to when and where, by whom possession was taken over. Now, after the award notice, immediately within a month thereafter, denotification happens. That is at page 110.
Yes.
18/5.
18/5/1998.
Yes. It is gested on 4/6. Page 110, Annexure C. ಇವತ್ತು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಇದೆ ಅದು. ಅಲ್ಲ, ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೂ
ಇದೆ. Those documents have the compilation of all.
Anyway, ಇದು this is denotified 464 ಕನ್ನಡದಲ್ಲಿದೆ. ಕನ್ನಡ ಅಂಕಿಗಳು page 111.
The government takes a decision to denotify?
Yes.
Yes. All right, government order. Notification.
Yes, government notification. And it's a gazette notification. And it is pursuant to the deliberations of the committee, which my learned friend Dr. Singhvi has already highlighted. Now, very important to take note here is that after the denotification, no further development has taken place. Possession was either asked or pursued after the denotification. Obviously,
But layout is formed, everything is done.
ತಾವು ಹೇಳ್ತೇನೆ ಒಂದ್ ನಿಮಿಷ.
ಅಲ್ಲ, no development has
Acquisition
taken
Act.
place.
ಅಲ್ಲಲ್ಲ, ಒಂದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್ ಒಂದ್ ನಿಮಿಷ ತಾವು ನೋಡಿದ್ರೆ
ಕೊಡಿ
ಸೆಕ್ಷನ್ 48.
Yes, denotification.
Yes.
Yes.
Old Act.
48 ಓದಿ. Yes. ಅದು ಇದು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ, ಅದಿರಲ್ಲ. ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. 482 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್
ಇಲ್ವಾ?
ಅಕ್ವಿಸಿಷನ್
ಇಲ್ದೇ ಇದ್ರೆ ನಾನು
ಇಲ್ಲ ಅಂತಾನೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಅದಕ್ಕೆ
ಓದ್ಬಿಟ್ಟು
ಓದಿ
pass
ಅಂತ ಹೇಳಿದ್ದು.
on section 48.
Yes.
1. Except in the case provided for in section 36, this does not come under that. The government shall be at liberty to withdraw from the acquisition of any land. Kindly mark the next phrase, very important. That's a condition precedent of which possession has not been taken.
Yes. At that time aware.
Sir, this is
48
condition precedent. When there is a notification and I have shown that no possession was taken, how can the governor come to the conclusion there is a possession with the MUDA? How can the complainant misrepresent to the governor?
Is it not that once final notification is issued and award notices, award is passed determined, it vests with the government?
Sir, vesting is different from possession,
All right.
with great respect.
Yes.
Otherwise, why would notice be given? More importantly, kindly permit me to show that under section 16, they are entitled to take possession.
Yes.
Six-
Land acquisition act. ಅದೇ
six-
ಸರ್ಗೆ ಕೊಟ್ಬಿಡಿ.
ಬಂತಾ? 16,
ಇದು ಬರಲ್ಲ, 5
16(1). ತಾವು ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ. Possession has to be taken under section 16(1).
Yes, sir.
And it is very well established that possession has to be taken by drawing a measure.
Yes, that is.
No such measure has
There is
been,
no measure drawn.
no measure drawn whatsoever.
Yes.
So 16(1) possession is not taken.
So the submission is, it's still vested, still the land was in possession of the legal heirs of Ninga.
It continued to be a
Continued to
private
be-
land,
Continued to be a private
land.
Therefore, it was not a subject.
And this was conclusively established when a 16(2) notice, 16(2) ತಾವು ಒಂದ್ ನಿಮಿಷ.
Yes,
16(2) notification was issued.
yes.
That notification we have placed before the court today, which is a gazette notification.
Hmm.
So if possession is taken, it will be notified in the gazette under subsection 2 of section 16.
16, yes.
Sir, ತಾವು ಇವತ್ತು page 53
ಇವತ್ತು ಕೊಟ್ಟಿರೋದ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ
ಇಲ್ಲ, yes.
document number 12, page
Yes.
53.
All right.
ಸೊ ಇದರಲ್ಲಿ ಕೆಸರೆ ಗ್ರಾಮ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಕೆಸರೆ ಗ್ರಾಮದ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ ಎನ್ಯೂಮರೇಟೆಡ್ ಆಗುತ್ತೆ 1 to 24. ಇದರಲ್ಲಿ 464 ಬರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ in seriatim the survey numbers are mentioned. Kindly come to item 34, which is 455. 455 ಆದ್ಮೇಲೆ 464 ಬರ್ಬೇಕಿತ್ತು. 466 ಕೊಟ್ಟೋಗ್ತಾರೆ. ಯಾಕೆಂದ್ರೆ 464 ತಗೊಂಡಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ಎಲ್ಲೂ 464 ಬಂದಿಲ್ಲ.
What is document 13?
13.
ವೈಯಕ್ತಿಕ award determination.
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೊಸೆಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, award notice ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. I don't dispute award notice.
ಅಲ್ಲ, after denotification. 15/2/1999.
I request the court to kindly mark one thing.
That's what, yes.
What happened was, now this notice was taken out on the basis of the common award that was made. I think common award is also produced.
ಅದೇ ಕಾಮನ್ ಅವಾರ್ಡ್ ಓದಿದ್ದೆ ಅವಾಗ್ಲೇ.
Ah.
Yes.
Common award. Page 29 alliದೆ. Yes. Page 29 ಅಲ್ಲಿ it is dated 31/10/97.
Yes. After the final notification.
464 is specifically mentioned in line number 4.
Yes.
ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ಗಳು.
ಆಮೇಲೆ ಅದಿರಲ್ಲ.
ಸೊ ಇದಕ್ಕೆ ಅವಾರ್ಡ್ ಆಗಿದೆ, ಕಾಮನ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ, ಇದು ಜನರಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದಕ್ಕೆ
ಹಾಗೆ
ಡೆಪಾಸಿಟ್ ಮಾಡಿ
1,52,00,000 ರೂಪಾಯಿ ಟೋಟಲ್ ಅವಾರ್ಡ್ ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ,
ಕಾಮನ್ ಅವಾರ್ಡ್
ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ. ಈ ಅಮೌಂಟ್ ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿ.
ಹೌದು.
ಅಂಡ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದೆ, ನೀವು ಈ ತರ ಲಂಪ್ಸಮ್ ಕೊಟ್ರೆ ಆಗೋದಿಲ್ಲ, ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಪ್ರತಿ ಲ್ಯಾಂಡ್ಗೂ ಕೊಡಬೇಕು ಅಂತ. ಇನ್ ದಿ ಇಂಟ್ರೆಗ್ನಮ್ ತಾವು ತೋರಿಸಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 13 ಬಂದಿತ್ತು. ದಿಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಕಾಮನ್ ಅವಾರ್ಡ್, ಬಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ an independent award. Be that as it may, he has not drawn that amount. No compensation was paid. It is nobody's case that compensation was received.
Was not claimed.
Not claimed, not paid.
Deposited in civil court, not
returned. No. What was deposited has been returned.
All right.
And that has lapsed.
That is 3,24,000.
No, entire amount was deposited for the.
ಅಲ್ಲ, page 60 ಪರಿಹಾರ ವಿವರ.
ಪರಿಹಾರ ವಿವರ ಅವರು ಅದನ್ನ
ನಿಮ್ದು.
ಹೌದು, ಅದು ಕೋರ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ. ಎಂಟೈರ್ ಅಮೌಂಟ್ ನ ಒಟ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ, ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ನಿರ್ಣಯ ನಿಮ್ದೇ.
ಅವಾರ್ಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ
ಕಾಮನ್ ಅವಾರ್ಡ್,
ಜನರಲ್ ಅವಾರ್ಡ್. ಎವ್ರಿ ಒನ್ ವಾಸ್ ಈ ತರ ನಿಮಗ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿಲ್ಲ. ಸೊ ದೇ ಡಿಪಾಸಿಟೆಡ್ ಇಟ್ under section 31.
No, these are all events that have happened earlier. You come into the picture in 2004, or the family comes into the picture in 2004.
No, with great respect, court heard them for over a day. That where is the land?
Over a day.
Allala, where is the land? Where is the village? I am answering that question.
All right, yes.
Where is the land? Sir, land is with me, my predecessor in title. It has never left my hand. It is still with me. I am the owner. I am the man in possession.
Then how did MUDA form layout in that?
Yes, that is the $1 million
If
question.
you knew that you were in possession of the land and it was conspicuous,
Yes.
then how did you permit MUDA to form a layout there?
My permission is needed.
No, ಆಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ತಾವು
You should have
ಕೇಳೋದ್ ನೋಡಿದ್ರೆ
objected
ನಾನು
to it.
ಪರ್ಮಿಷನ್ ತಗೊಂಡ್
Well,
ಮಾಡ್ತಾರೆ.
you have not objected to it any time.
No,
but
no,
this
with
is
great
land.
respect.
How are you
No,
forming a layout?
why should I object
Need not
when-
object.
when the layout plan excluded this particular land?
But even then, land layout is formed in your land.
May ಇದು plans ಇದೆಯಲ್ಲ? ಇದೇನು? Yellow.
So anyway, the family comes into picture in 2004. Let's
Sir,
fast
kindly-
forward.
kindly come to page 52. Kindly come to page 52.
50?
52. ಇದು ಬೇರೆ ಫೈಲ್ ತಂದಿಲ್ವಾ? ಇದೆ ನೋಡಿ, ತೆಗಿರಿ. ಎಲ್ಲೋ ಫೈಲ್ ಒಂದಿದೆ. Page 52. The marked portion in page 52 the layout plan
Huh.
expressly declares that this is a denotified land.
Yeah. Yes.
So this was not included in the layout. It was left out. And I have the copy of the approved plan. I'll give it. There also, the survey numbers which are being subjected to the development are also specified. 464 is left out. So this was not part of the layout.
Yes.
So in these circumstances, the land has never left the
Hands of Devraj.
Devraj. It remained with him. He sold it in favor of my brother-in-law.
Then comes the
Yes.
family. into the
That
picture.
learned senior counsel has already covered. I'll not trouble the court.
So ಈಗ layout form, what is that?
The need of suspicion.
ಅಲ್ಲ,
the-
schemes.
The reason why I'm now the governor
Need of
proceeds.
suspicion.
The governor proceeds on the footing that possession is taken over. And my learned friend, Mr. K.G. Raghavan, eloquently argued the need of suspicion. ತಾವು ರಿಪೀಟೆಡ್ಲಿ ಕೇಳಿದ್ರಿ ಏನು ಇವ್ರ ರೋಲ್ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಯಾರು ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ. ದಿ ನೀಡ್ ಆಫ್ ಸಸ್ಪಿಷನ್ ಇರೋದ್ರಿಂದ ತಾವು ಅದಕ್ಕೂ ಹೇಳಿದ್ರಿ ಹೇರ್ ಸ್ಟ್ಯಾಕ್ ಅಲ್ಲ ಅಂತ. ಸೊ ದಿ ನೀಡ್ ಆಫ್ ವೇರ್ ಇಸ್ ಸಸ್ಪಿಷನ್ ಸರ್? ವೇರ್ ಇಸ್ ಪೊಸೆಷನ್? ಇಟ್ ಈಸ್ ವಿತ್ ಮೀ. A false statement is being made in the complaint that possession is with MUDA. Governor records a perverse finding that the possession is MUDA, and the entire case is built up on that foundation. The possession has never been handed over. The taking over of the possession is not even notified under section 16(2). And the layout plan, I'll place the certified copy. Idರಲ್ಲಿ clear ಆಗಿಲ್ಲ.
All right.
So the land is very much there. It remained an agriculture land till it was converted.
Till it was converted.
Yes.
Which is this layout scheme that MUDA formed?
That's what I want to place it. ಇದನ್ನೇ ತಾವು
A
ನೋಡಿದ್ದು.
layout scheme was formed even in 464.
No. No.
All right.
I'm going to place the official plan,
All right.
approved plan.
So according to you, in 464, no layout.
It was
plan.
not part of the layout. It was specifically excluded as a denotified land. And the number of the survey numbers were specifically enumerated. This was not included in the survey numbers that formed the project layout. I'll place it before the court.
All right, no problem. Yes, we'll take your statement.
So the entire case is built on this. MUDA has taken over possession. MUDA has developed the land. And that is the finding recorded by the His Excellency the Governor. So this is the foundation for the Governor's order. Kindly permit me to resume the
Yes,
reading of it.
back to the,
It makes further interesting.
bring back to the governor's order.
Back to the
Yes.
Governor.
Yes.
ಅದನ್ನೆಲ್ಲ ಯಾತಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇನ್ 31.1 ಅಂದ್ರೆ ಪೊಸೆಷನ್ ತಗೊಂಡಿರೋದು. The aforesaid aspect have not been examined and considered by the Council of Ministers.
That is why he terms it to be irrational.
Possession. So it's a comment on the Council of Ministers advice. Now kindly come to para 31.4. In the present matter, page 18.
Yes.
In the present matter, the allegations and the material in support of the allegations would prima facie indicate that the said land was given to SC person due course of law.
Yes.
The records of the said land was transferred from the father to the children and again from children to father. So this is a fantastic story of the governor. Where is it?
Children to father.
This is what governor has written.
Okay.
Kindly,
Father was not there by.
kindly see the ಅಲ್ಲ ಇದು ಬುರುಡೆ ಬಿಡ್ತಾ ಹೋದ್ರೆ ಅದಕ್ಕೆ ರೈಲ್ ಇರೋದಿಲ್ಲ, ಹಳಿ ಇರೋದಿಲ್ಲ, ಹಿಂಗೆ ಹೋಗ್ತಾ ಇರುತ್ತೆ. Kindly see para 31.
That I have seen.
Yes. So the records of the land was transferred from father to children, again from children to father, and this mystery was considered by the state cabinet, was not considered by the state cabinet. How should they imagine that this kind of a story would be written in the governor's order? They would have considered it. So this is the first reason. When the notification for land acquisition issued and the notification order was issued, Siddaramaiah was the MLA, etc., etc.
Is on the.
Yes, yes. Now all this, why is he saying all this?
Power timeline of the chief minister.
No, all this, why is he stating? Kindly come to the bottom of that paragraph.
Hmm.
Due to the apparent bias, the present matter requires my independent application. Now, Shivbhaktan kate ಹೇಳಿದ್ನಲ್ಲ. Cabinet advice, ಬರೀ cabinet advice ಬಗ್ಗೆನೇ he is obsessed. So it is biased. Next also 31.5. Again he is on the cabinet advice. Cabinet Council of Ministers, the Council of Ministers do not consider the entire material in support of the allegation. 31.6.
Yes.
He quotes the Madhya Pradesh case.
Hmm.
I request the court to kindly permit me to read 31.8.
Hmm.
Dr. Singhvi has elaborately argued.
Yes.
But only one aspect I would like to. Very, very disturbing finding has been recorded by the governor in para 31.8. In view of the aforesaid, it emerges that the present situation amounts to peril to democratic principles. Sir, in the last 50 years, kindly take judicial notice of this fact. Siddaramaiah is the only man who has served full term of 5 years. And he is now re-elected. And the governor has this thing to say that democracy is in peril. He is a nominated governor, an elected man with such an overwhelming mandate, a man who has ruled the state without any blemish. I request the court to kindly take it. Is it not a disturbing finding that the governor has indulged in? Kindly look at the predecessors who ruled the state. What has happened to them? What kind of situation they have faced? And a man who has been in power for such a long time, ಒಂದು ಜುಜ್ಬಿ ಸೈಟ್ಗೆ ಇಷ್ಟು ಇದನ್ ಮಾಡ್ಬೇಕಿತ್ತು. 23
ನಿಮಿಷ. ಜುಜ್ಬಿ ಸೈಟ್ ಅಂದ್ರೆ
ಅಲ್ಲ, ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ, ಅಲ್ಲಲ್ಲ ಜುಜ್ಬಿ
ಅಲ್ಟಿಮೇಟ್ಲಿ ಅದು ಹಾಗೆ ಆಗಿದ್ರೆ ಇವ್ರು ಏನು ಮಾಡ್ತಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ
55 crores ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಅಷ್ಟೇ.
ಇಲ್ಲ ಇಲ್ಲ, ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ, ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಕುತ್ಕೊಳ್ತೀರಾ?
ಎಸ್.
ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ರೆ 60-40 ಅವ್ರ ತಕರಾರಿಲ್ಲ, 50-50 ತಕರಾರಿದೆ. ಅಂದ್ರೆ ಇನ್ನೆರಡು ಸೈಟ್ ಎಕ್ಸ್ಟ್ರಾ ಬಂದಿರಬಹುದು.
ರೇಷಿಯೋಗಲ್ಲ ತಕರಾರಿರೋದು. ದಿ ಅಲ್ಟಿಮೇಟ್ ಬೆನಿಫಿಷಿಯರಿ ಟು ಒನ್ ರೂಫ್ ದಟ್ ಹಸ್ ಗಾನ್, ದಟ್ ಇಸ್ 55 crores is the problem ಅಂತ. That is what they are
No, with great respect, it is in respect of her land.
Is what their project.
No, 3 acres 16 ಗುಂಟಾಸ್ ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಡಿ, ಮುಗಿದೋಯ್ತಲ್ಲ. Anyway, it is not a denotified land, admittedly.
Not a denotified land.
It is a denotified land.
Notified.
Denotified land. It ought not to have been subjected to layout formation. They have encroached and done it. ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು. ಅವ್ರ ಲ್ಯಾಂಡ್ ಅವ್ರು ವಾಪಸ್ ಕೊಡಿ. ಅದಕ್ಕೀಗ ಇಷ್ಟು ಸೈಟ್ ಕಾಂಪನ್ಸೇಟರಿ ಸೈಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಕೊಟ್ಟಿರೋದು ಸಿದ್ದರಾಮಯ್ಯ ಅಲ್ಲ, ಅದು ಕೊಟ್ಟಿರೋದು ಮೂಡ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅದರದೇ ಆದಂತ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇದೆ. ದೇ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್. Sir, kindly take judicial notice of this fact. When one man is in power, so many things may be happening. Somewhere some of his relatives may be benefited. There may be officers who are overzealous. ಮಾಡಿರ್ಬೋದು, ಮಾಡಿಲ್ದೇ ಇರ್ಬೋದು. ಬಟ್ ಅದಕ್ಕೆ can you hold a man who is at the helm of the affairs, who is ruling the state with such popularity, subject him to this kind of cavalier treatment?
What has happened?
Sir, sanction.
Approval.
He says sanction.
ಇಲ್ಲ, ಅದು ಆಮೇಲೆ, that is.
ತಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಅದನ್ನ ಅಪ್ರೂವಲ್, ಅವ್ರು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದು ಅಪ್ರೂವಲ್ ಅಂತ. ಅವರು he says it is a sanction. So this 31 point
So
itself,
it is not that the edifice is now shaken. It's approval.
no, 31.8, the finding there, it betrays the mind of the governor. The political,
We will answer.
the political vendetta he has got in taking this decision. We have attributed
Yes, that
political motives,
I have seen.
and he has not refuted them by any affidavit. My learned colleague instructs me. There is absolutely no scam against him, and therefore they have brought up this.
I saw Billy doing it. Yes.
So
Yes.
it is in this state of affair. I request the court to kindly. So this is the needle of suspicion my learned friend was harping upon.
Needle that
There-
is now
there-
prick,
there
the
is-
needle that is now pricking.
There is no suspicion, there is no gray area. The possession is with me,
Hmm.
and therefore they have to compensate for having encroached upon it.
Yes, sir.
And
You have any judgments to?
I
give?
have already given Article 20, this thing. Now
Ah,
that,
that is, yes.
yeah, now
Post
that,
facto.
yeah,
Post facto with regard to
yes.
provisions under the BNS.
Now that they have considered,
ಅದು sanction 17A ಮಾತ್ರ ಈಗ.
ಈಗ 17 year. So I'll not further trouble the court
So
with
that,
either.
that may not be required. Post facto finding need not be gone into.
ಓದಿಲ್ವಾ? 17A ಗೆ ಒಂದು ಜಡ್ಮೆಂಟ್
ಕೊಡಿ.
ಕೊಟ್ಟಿಲ್ವಾ? ನನಗೆ ಕೊಟ್ಟಿದ್ರಲ್ರಿ, ಕೊಡಿ. This is this is a case of Shankar Bhatt versus State of Kerala, 2021.
ಶಂಕರ್ ಭಟ್.
ಇದು ಕೊಟ್ಟಿಲ್ವಾ
ಶ್ರವಣ್ ಕುಮಾರ್ ಅಂತೇನೋ ಇದೆ.
ಸರ್? ಇದು ಕೊಟ್ಟಿದೆ, ಆಗ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಂಪೈಲೇಷನ್ ಇದೆ. ಸಾರಿ,
ಕಂಪೈಲೇಷನ್. ಶಂಕರ್ ಭಟ್ ವರ್ಸಸ್
ಕೊಡಿ ಕಾಪಿ ಇದೆಯಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಡ್ತೇನೆ ನಾನು. ಸಾರಿ,
ಇಲ್ಲ,
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಓದ್ಬಿಟ್ಟೆ ಕೊಡಿ.
ಹಾ.
ಇಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಇಟ್ ಹಿಯರ್.
ಕೊಡ್ತೇನೆ.
ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದು
ಇದರಲ್ಲಿ
ಯಾವ್ದೋ
ಇಷ್ಟೇ
division bench.
ಅವ್ರು ಹೇಳೋದು ಸೆಕ್ಷನ್ 17A, ದಿ ಹಾರ್ಟ್ ಅಂಡ್ ಸೋಲ್ ಆಫ್ ಸೆಕ್ಷನ್ 17A is recommendation or a decision. That is, I'll
That
pass on.
statute ಅಲ್ಲಿ ಇದೆ.
Then, so with these submissions, I rest my case. Grateful to you.
Yes. ಅಷ್ಟೇನಾ? ನಿಮ್ದು ಇದೆಯಾ? Well, it should not go on. It can't go on like.
ಕೆಸರೆ ವಿಲೇಜ್ ಬಗ್ಗೆ ನಾನು ಒಂದು ಹೇಳ್ಬೇಕು.
ಅದೊಂದು ಹೇಳ್ಬೇಕು. Because he says Kesare village is not there at all.
ಸರ್, 2011 ಅಲ್ಲಿ ಸೆನ್ಸಸ್ ಮಾಡಿದ್ದಾರೆ.
Hmm.
And according to the census, I'll place the census report also.
Hmm.
But I can give the data, census data. According to the 2011
Hey,
census,
why all of you have got up? Sit down. Yes.
ನಂದು ಇದೆಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್. Not only Kesare village is intact, but Kesare village consists of several ಸ್ಕೂಲ್ಸ್ ಇದೆ, ಹಾಸ್ಪಿಟಲ್ಸ್ ಇದೆ, ಓವರ್ 2000 acres ಲ್ಯಾಂಡ್ ಇದೆ ಕೆಸರೆ ವಿಲೇಜ್ ಅಲ್ಲಿ. Now, of course, it forms part of the uh,
That
Muna-
scheme,
city corporation.
ಅದೇ,
It
now
has
in the
come-
MCC.
Yeah, yeah.
Yes.
I'll place that data. That
Your Lordship, just a
Kesare
short-
village was subjected to census 2011 ಅಲ್ಲಿ. Full data is available, entire population data.
That's the last census.
And the lands particularly, ಕೆಸರೆ ವಿಲೇಜ್ ಕಳೆದೋಗ್ಬಿಟ್ಟಿದ್ರು, ಕಳೆದ್ಬಿಟ್ಟಿದ್ರು. I want to show,
Submission was made.
Yes.
Yes.
therefore I'll place it.
With your Lordship, can just a short note, my lord, on just with regard to prerequisite of prior to 17A, my lord. Just a short note. I'll just give the
Where
submission.
prerequisite?
Your Lordship, may kindly three issues which I have dealt with, my lords. First one is with regard to preliminary inquiry to determine the commission of a cognizable offense is a prerequisite for seeking prior approval under 17A. So therefore, my lords, prior to filing an application under 17A, my lords, a preliminary inquiry as per Lalit Kumari lines of judgment. I was not speaking about preliminary inquiry under 17A. Pre-17.
That's
The second issue is section 17A of the Prevention of Corruption Act does not provide for preliminary inquiry by the competent authority as provided under 173, my lords. Because what is required under 173,
according to your preliminary inquiry is also by police officer.
please, my lords.
That's right. All
So,
right.
so therefore, it does not contemplate 173 inquiry by the competent authority. Because what is the nature, what is, it's only a prior approval of the material as per the SOP, my lords, which is to
That's
looked into while deciding, my lords.
page 704.
Please, my lord. The last issue is when an investigation officer forms an opinion of a cognizable offense, the standing operating procedure dated 3rd September 21 requires submission of information or data in the form of the proposal to the competent authority in order to seek prior approval under section 17A of the PC Act for conducting inquiry or investigation. So therefore, my lord, what is required is that report, my lords, for which prior approval is given as per the prerequisite. So therefore, my lord, if that is not there, my lord, it is premature in that sense, my lords, to
Is premature.
the application to consider 17A.
ಯಾವಾಗ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನಿಮ್ಮ ಪ್ರಕಾರ?
So it would have been, ought to have been given if there was a preliminary inquiry pre-17A, or in the event worst scenario, my lords, if the competent authority, assuming, my lords, in the case it was not a governor, otherwise every competent authority will become an investigating officer while giving sanction. my lords.
Approval.
Prior, I stand corrected,
Hmm.
prior approval. So therefore, my lords, he can't do the work of both preliminary inquiry of,
You told that the
so
other.
therefore, my
Both
lords,
can't do the work of the IO and competent.
and competent, in support of that, my lords, under, only under 17A, my lords, and Lalit committed series of judgments, I put judgments which speaks about this situation.
No, one factor we must consider is when Lalita Kumari was rendered, statutory 17A ಇರ್ಲಿಲ್ಲ.
Please,
17A ಬಂದಿದ್ದು 2018 ಅಲ್ಲಿ.
correct.
So whatever is Lalita Kumari, we immediately apply or who should conduct, these are all, it's a gray area
See,
still.
that's why my daughter Ashok's your lordship judgment, my lords, that's the only case which deals with private person, my lords.
Yes, private
That-
complaint, that's the only.
That's the only case, and this is the next case which your lordships are dealing with 17A application, all that is prior to that. So the point is this, my lords, if preliminary inquiry is mandatory under 173(3) as well as per Lalit Kumari, if a cognizable offense is made out, my lords, by the IO, then 17A is an additional protection. It's an additional protection.
After cognizable offense is made out.
Please, my lord, that is what 17A says. 17A says no police officer, my lord,
Of a cognizable offense.
of a cognizable offense. So therefore, reading Lalit Kumari and 173(3), my lords. So therefore, my lord, the whole purpose of those line of judgments will be rendered odious, and again giving the power back to the competent authority to, the your lordship may kindly forgive this case. Tomorrow, anybody, the minister or chief minister, that apart, any competent authority, any person can go give a complaint, he can,
Anybody can set the criminal law into
no,
motion.
without, in case of protection under either,
ಅದಕ್ಕೆ I have written 17A approval ಇಲ್ಲದೆ no man
Ah.
can set the criminal law into motion.
is-
Quay. PC Act offences.
Correct. So therefore, 17A becomes premature.
Huh?
Because the same, like, if your lordship take it to its logical and my lord, in that sense, 17A becomes premature unless that is done. So
Will consider.
that's all. I just.
But,
ಅಲ್ಲ 5 ನಿಮಿಷ ಅಷ್ಟೇ.
please, please.
Yes.
Since learned senior friend concluded with.
No new facts,
No, no, no.
only answering. Yes.
Please.
5 minutes also, Your Lordship, closing.
ಹಾ, ಎಲ್ಲರಿಗೂ.
In connection to the private complaint, my lord. Since it was concluded with how the court must deal, my lord, when a private complaint is.
ಇದು 17A ಹೇಳಿದಾರ
How
ಇದ್ರಲ್ಲಿ?
the special.
17A ಹೇಳಿದಾರ?
17, please, please, very much.
Is after my judgment or before?
Division bench of the.
Madhya
Madhya Pradesh.
Yes.
Please. But I invite my lordship's kind attention to page 16, my lord.
Hmm.
10.4, paragraph 10.4. Thirdly, section 17A does not bar the special court from conducting inquiry or inquiry as defined in section 2G of the Code of Criminal.
CRPs, yes.
Please. Argument may be raised that though the special court is not statutorily barred from conducting inquiry, but occasions may arise where the special court for aid and assistance may direct police to conduct inquiry, leading to an impasse in the face of statutory bar under section 17A, prohibiting police officer from proceeding ahead. True, it is that the police officer alone has been restrained from conducting inquiry or investigation, but the said argument can be put to rest by the well-established principle of law that what cannot be done directly in law also cannot be done indirectly.
As simple. Yes.
Therefore, please,
As simple as that.
please, my lord.
Yes.
So, my lord, I would, my lord, straight away draw my lord's kind attention to the operative portion, please.
This is exactly what is written.
Please, our
Yes.
para 10.7. Not so the special court, my lord.
See, this is what others were doing. What could not be done directly by taking an approval under
Please.
17A?
Please,
Go before the magistrate, get the matter referred, FIR registered, no 17A. That was being done indirectly.
Please.
That is why Ashok was
this is
written.
in conformity with Dr. Ashok.
Yes. ಆಮೇಲೆ
My lord, my learned senior friend, my lord, made an assertion that the land, my lord, the possession was never taken. And so it stood vested with the erstwhile owners. Lord, that is in fact self-contradictory to the claim made by the petitioners. Because she in her application, the two applications, my lord, dated 2014, another application dated 2021. She makes a claim that in the year 2001 itself, MUDA has utilized survey number 464. Although, my lord, she or her family members were nobody at the relevant juncture, as observed by my lords earlier. Lord, then the claim itself becomes fraudulent, my lord. Now they say possession has never been taken. Now you come back to 2014 and say possession has been, the land has been encroached, possession has
No,
been
no,
taken.
that
by
is in answer to your submission that possession is not taken at all. ನೀವು
possession is-
ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಆನ್ಸರ್ ಕೊಡ್ತಾನೆ ಇರ್ಲಿ.
Certainly, my lord. Now the claim becomes fraudulent because in the year 2001 itself, now they claim that the MUDA had formed sites, parks, layouts, and other civic communities in the year 2001 itself. My lord, they cannot, my lord, make a claim contrary to their application, seeking. And interestingly, my lord, after a while, my learned senior friend makes a submission that encroach ಮಾಡಬಾರ್ದಿತ್ತು. Encroach ಮಾಡಿರೋ ಜಾಗಕ್ಕೆ why did your brother-in-law go and seek for conversion? My lord, they cannot have a double standard approach, my lord. In fact, this is triple standard. Encroach ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಪುನಃ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ. Why did you go and seek conversion?
All right.
And they expect this honorable court to believe that by pursuance of a common man, Mallikarjunaya, that both Tahsildar and Deputy Commissioner of the concerned jurisdiction, they come to this spot, inspect and form an opinion that they have found and identified an agricultural land. When no, my lord, they say that the land was encroached. But kindly, my lord, this can be taken note
Land
of.
was encroached ಅಂತ ಎಲ್ಲ ಹೇಳಿದ್ರು.
That is what they claim in the application.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಬ್ಮಿಷನ್ ಏನ್ ಮಾಡಿ?
Yes. No, ಮಾಡಿದ್ರು.
All right.
That submission was made. Encroach ಮಾಡಬಾರ್ದಿತ್ತು, ಮಾಡಿದ್ದಾರೆ. That was made, my lord, in the open court.
No, that is the reason for asking compensation.
Please, my lord.
So that being the case, my lord, now they cannot now, my lord, have multiple, my lord, approaches. Whether it was encroached or not, whether conversion was sought or not. That's the question, my lord.
ನಾವು ಕೊಡ್ಬೇಕು.
Please.
ಸಾಕು.
ಪ್ರಶ್ನೆ ಯಾರು ಕೇಳ್ತಿದಾರೆ ಅಂತ.
Lord, now I have filed a written synopsis.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ,
Please.
ಕೊಟ್ಟಿದ್ದೀರ ರಂಗನಾಥ್?
I have given. In fact, my lord said sought for the same, the earlier occasion. Yes.
ಹಾ, ಎಸ್ ಸರ್.
Lord, in the year 1999, my lord, as observed by my lords, individual award came to be passed. It's
That is the document.
it's not as claimed as though a universal award was.
Common award was first passed.
Subsequently, it was.
ಆಮೇಲೆ
Please.
ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ವಿವರ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಕೊಟ್ಟು ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ,
Please, please.
ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು.
My lord, when, my lord, the land was denotified, my lord, how could, my lord,
1998.
1998, after a year, my lord, the amount is deposited, the award amount. How could it be possible, my
No,
lord?
that is perhaps because of the common
Whether-
award ಅಂತ ಹೇಳಿ.
Whether such a denotification document is an afterthought and whether it is planted,
Sir, government notification after thought, gazette notification after thought ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
but there are,
Amount has been returned by check. The
No.
amount.
ಆಫ್ಟರ್ ಥಾಟ್ ಆಗತ್ತೆ, ಅದು ರಿಟರ್ನ್ ಆಗಿದೆಯೋ ಅಲ್ಲ ಬೇರೆ ಮಾತು. ಗಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆಫ್ಟರ್ ಥಾಟ್ ಇದೆ. 99 ಆದ್ಮೇಲೆ 98 ಕೆನಾಟ್ ಕಮ್ ಆಫ್ಟರ್ ಥಾಟ್.
ಮೂಡಾದವ್ರು ಕೊಟ್ಟ ಇದು ಕಾಂಪನ್ಸೇಷನ್ ಇಟ್ ಹಸ್ ಬಿನ್ ರಿಟರ್ನ್ ಬೈ ಚೆಕ್.
ದ ರೂಟ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
ಕೊಡ್ತೇನೆ ಅದನ್ನ ಡೀಟೇಲ್ಸ್.
The AG always gets into the root of the matter.
my humble submission is, without, my lord, scrutiny, amount can never be deposited, my lord, in the jurisdictional court. That has been done. Now subsequently, my lord, initially, in the year 2014, my lord, after the application is made, the decision is taken, my lord, to, my lord, compensate the petitioner's wife in the ratio of 50-50, my lord, in a similar layout, Subsequently, another decision is taken after another 3 years, my lord, wherein decision has been taken to compensate her with a land which is undeveloped and in possession of MUDA. Now, out of nowhere, my lord, the compensatory sites are allotted in upmarket Vijayanagar area, which is a posh locality, which is an upmarket area. Devanoru Badavane, my lord, can't be equated to Vijayanagara, just like Sadasiv Nagar of Bangalore.
In Vijayanagara?
Yes.
Oh.
In Mysore, that is the stature of.
I thought Jayalakshmipuram.
Not at all. Not at all.
All right.
Devanoru Badavane is like Chintamani.
Oh, all right.
So such is the.
I always knew that Jailpuram was equated to Sadashiv Nagar.
Such is the difference, my lord. Such is the difference between Devanoru Badavane and Vijayanagar. That apart, my lord, the special land acquisition officer, when he directs the petitioner's wife, my lord, he refers to certain meetings, my lord, of the year 2017 and of the year 2021. But when the allotment is made, out of nowhere, my lord, a meeting dated, a meeting of the year 2020 is referred to.
That nothing happened in that. 2021 meeting supersedes that 2020 meeting.
Please,
A document illa 2020.
he claims that in the year 2020, a decision has been taken and pursuant to that decision, allotment has been made.
I don't, resolution is not even there of 2020. I don't know what is that.
But it is there.
19/9/2020 ಅಂತೇನೋ ಇದೆ ಅದು.
ನಾವು ರಿಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಬೇಡ ಸುಮ್ಮನೆ ಇರಿ. Yes, ರಂಗನಾಥ್. ಅದೆಲ್ಲ ಹೇಳಿದೀರಾ, ಸಿನಾಪ್ಸಿಸ್ ಹೇಳಿದೀರಾ, I will go through it.
My humble.
ಮತ್ತೆ ಇದಕ್ಕೆ ರಿಪ್ಲೈ ಅದೆಲ್ಲ ಆಗಲ್ಲ.
Page 178 to 194, my lord, the allotment letters are placed.
Allotment letters are placed, yes.
If at all, my lord, in the year 2020 itself, decision was taken to compensate the petitioner. Right? Why would, my lord, she once again, my lord, approach the MUDA with a letter dated 2021, my lord? Once again, another letter is written claiming compensation. My lord, these facts, my lord, would certainly, my lord, warrant investigation as to how.
ಅದು ಹೇಳಿ.
Please. Lord, lastly, my lord, coming to the antecedents, my lord, because there are some serious.
That you may have to reply.
Please, please.
ಅದನ್ನ ಮಾಡೋದ್ ಬಿಟ್ಟು ಇದೆಲ್ಲ ಬೇಕಾಗಿದೆ. ಇದೆಲ್ಲ ಹೇಳಿದ್ರಿ ಆಲ್ರೆಡಿ. What is that 25 lakhs? Because the submission is made, I have to answer that all.
Please. Sorry. The fine, my lord, was levied in connection to a PAL, my lord, preferred by the respondent number 3.
Hmm.
Please.
Hmm.
Lord, on the relevant day, he was, my lord, represented by his counsel, my lord. And at page 130, my lord, the operative portion, my lord, therefore, while discussing the SLP, we impose 25 lakhs.
Hmm.
Now, thereafter, what happens is that, my lord, the petitioner, once again, my lord, he approaches the court and, my lord, explains as to, Lord, actually what transpired is that, my lord, it so-
Reduce costs,
Please.
amend the application.
so happens, my lord, that the petitioner, my lord, he had interested his counsel,
Oh, ಅದನ್ನ 1 lakh reduce ಮಾಡಿದ್ರ?
reduce ಮಾಡ್ತಾರೆ. In fact, they insisted on reduction. No, that, my lord, is nowhere told, my lord. We asked for extension.
No, that's
In
why
fact,
I
we
said,
never sought for reduction.
sometimes whistleblowers face all this.
Please.
It's not that, yes.
Now, what happens is that, my lord, in fact, the brief, my lord, with the counsel on record at that relevant point of time, Ali, the file, my lord, would be of some other case.
No, that's all right.
Please.
It is reduced to 1 lakh.
Bona fide error was, my
That
lord,
is not a
appreciated.
problem. Then what is that outraging the modesty allegation?
Please, my lord. Now, page 77, my lord, may kindly be of the writ petition, of the statement of objections, my lord. which I-
ಏನ್ ಹೇಳಿ ಅದು?
Please,
Which is that complaint?
my lord, in fact,
That PC
please.
Act complaint?
please, based on the complaint, my lord, of the respondent number 3, my lord, there were certain raids, my lord, which are taken. Now, my lord, as a counter blast, there was a complaint, my lord, lodged against the respondent number 3. That, my lord, they are projecting as though the respondent number 3 is a convict. That is how, in fact, there are 2 cases, my lord, registered against the concerned complainant by the respondent number 3. And in fact, my lords is looking.
The other
into-
one which was the other
Please,
day.
please. But paragraph,
Hmm.
paragraph E, my lord, page 77, my lord, of my statement of objection.
ಹೇಳಿ ಓದಿ.
But page 82, my lord. But these are, my lord, the list of cases, my lord.
You have rebutted everything that is said in the petition,
Please,
quay the antecedents,
please.
all right,
There's a separate paragraph, my lord, paragraph E.
all right.
Coming forth at page
Regarding
77.
paragraph AE,
E, my lord, page
AE
77, my lord.
77. Ah, yes.
77, my lord.
Yes, yes. Regarding antecedent.
Please. Now, every allegation, my lord, is answered. Now, my lord, page 81 may kindly be perused. The mining case, my lord, which the respondent number 3 had approved it, is still now, my lord, being directly, my lord, monitored by the Honorable Apex Court.
I know.
Please. And there are so many other cases which are,
That is why that statement was made.
please. But in fact, at the risk of sounding political, my lord.
So don't sound political.
Kindly, my lord. But in the last 2 decades, my lord, if the history of the state of Karnataka is seen, Lord, no political party, either be it the ruling party or the opposition party, they have uprooted either each other's scams or scandals. my lord.
Don't,
It is only these respondents,
See,
my lord,
these
who seek
are
their
co-
life and limbs, my
these,
lord. They
these,
have, my lord.
we are in a court of law.
Please, please.
The argument should be apolitical.
My humble submission is,
Yes,
it is these private complainants. my lord. If the history is
I
seen,
told you again,
please.
I have made a statement that whistleblowers do suffer such things. It is not in the air made. Yes,
No, my lord, because serious allegations were made.
all right. You have countered that, I will consider. Yes. Yes,
I'll submit that plan
ಅದ್ ಕೊಡಿದ್ದಾರೆ.
so that they may also ಎಷ್ಟೊತ್ತಿಗೆ
ಅವ್ರು ಮತ್ತೆ ಇನ್ನೊಂದು ಪ್ಲಾನ್.
ಇಲ್ಲ no. I've already made my submission.
Yes.
That material I'll place before the court, the sanction plan and the census data.
Yes, madam.
ನಾಳೆ ಎಷ್ಟೊತ್ತಿಗೆ ಅವ್ರು so that
ನಾಳೆ ಇಲ್ಲ, ಮುಗೀತು ಇವತ್ತೇ.
ಅಲ್ಲ ಅವ್ರು ನಾಟ್ ಬಿಹೈಂಡ್ ದೇರ್ ಬ್ಯಾಕ್.
ಅಲ್ಲ, ಆತರ ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟು
Very well,
file it
very
before.
well.
I am not listing this matter.
ಇಲ್ಲ ಬೇಕಾಗಿಲ್ಲ. No arguments.
Yes, sir.
I thought I'll,
Not for anything, listing ಏ ಇಲ್ಲ.
okay,
Yes.
very well.
Page 33 may kindly be.
Of what, sir?
My written synopsis.
Synopsis, sir.
Please.
ಹೇಳಾಯ್ತಲ್ಲ ರಂಗನಾಥ್ ಮತ್ತೇನು?
Only couple of minutes, please.
ಹಾ ಹೇಳಿ. Couple of things,
Couple of minutes.
minutes.
Lord, regarding Lalita Kumari's case, my lord, what the court, in fact, the learned AG had addressed this honorable court, my lord, that.
ಅಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಆಗ್ತಿರೋದು ನೋಡ್ರಿ 10:30 ಅಲ್ಲ ಈಗ 6:30 ಆಗ್ತಾ ಇದೆ.
Couple of
ಎಸ್ ಸರ್.
preliminary inquiry, my lord, not exceeding 7 days. There is clear, my lord, gap of 7 days, my lord, before.
I told that right. ಲಲಿತ್ ಕುಮಾರಿ ಸೇಸ್ ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೈಯರ್ ಆಫೀಸರ್.
Lord, all that, my lord, I want to say is that when Lalita Kumari was rendered, section 17A, my lord, was not.
ಅದನ್ನು ಹೇಳಿದ್ನಲ್ಲ.
Please.
Ah.
Lord, because there are multiple, my lord, assertions made in connection to this.
We will answer.
As well as Priyanka Srivatsa's case. So both, my lord, while complying with section 154 subclass 1 and 154(3), my lord, there is clear gap of 7 days, my lord, before I take the next step. So therefore, that has been completely complied with.
I will look into it and ask. Please, yes.
Lalit Kumar has been modified to 15 days to 6 weeks, my lord, not 7 days. ಇಲ್ಲ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ.
Yes.
None of them, Your Lordship.
ರಂಗನಾಥ್.
Please.
Closing, Your Lordship.
ನಿಮಗೆ 5 minutes ಸಾಕು ಹೇಳಿ.
That's it. 12 points, Your Lordship.
12 points.
5 minutes will be done.
Yes.
They had mentioned that it was 23 years is what they had mentioned. That it took that long. Could have been done within one period of 5 years. The difficulty for them was there was a huge blunder. The blunder committed took 15 years now to undo,
Madam, 1 minute.
reboot.
1 minute. Blunder committed 15 years. Where were they in the picture in 15 years? Everything has happened on its own.
No,
They
no.
come into. You mean to say
They
that,
don't-
are you saying that the chief minister was of the idea or the family of the chief minister or idea of buying this land in 1997?
No, not at all.
No.
A4.
2004, the story commences from
It
this family.
doesn't commence from the date that the brother-in-law buys it.
Yes.
It commences from the date A4 applies, asking for denotification.
That
This
is
is,
Devraj.
yes, Devraj.
Devraj is an accused.
He's an accused. Now, what he does is, he works in the education department. He suppresses it. The whole scheme of all of this starts with a misrepresentation. He states, this is my only source of income. This is my agricultural income. And therefore, please denotify. Whereas he works here in the education department. It starts with that. And as I had taken your lordship through the periods when this was involved, it started from there. So from the period when Devraj had applied, it started. So what I'm trying to say is that 23 years is a fault of theirs, not ours, that they made a big blunder in the way they went about it. After finishing with denotification and then conversion, and then, oops, we've gone the wrong way. Maybe we need to take another route. And then applications start for compensatory sites. Now, the other issue that they seem to mention is that 50-50. It is not 50-50, reason being, in the MUDA sale deeds to the wife of the petitioner, it states clearly that it's under the 1991 scheme. Now, the reason this is extremely important, Your Lordship, is that 60-40 allotment. If it is 60-40, say about in an acre, development 45% goes, 55% is only left. In 45 allotment, the parks, the roads, the amenities, all of that. 55% is left. In 55%, 40% of that is what a landowner is entitled to, which is be about 22%, which is about 9,500 square feet in 1 acre. 3 acres, let's assume for a minute that they have a flow of title, which they don't. 3 acres, they would have to get at best 28,000 square feet. What is given is on the 50-50 scheme,
Correct.
38,000 square feet.
Government had changed the scheme by then, 50-50 had come in.
The sale,
2015.
the sale deed itself talks of what scheme would be applicable to them. So the question of changing that would not arise. Your Lordship, as he had mentioned, I have to just make it very clear where Devanuru comes. That is this village that they're talking about. It's precisely 2 hours from Mysore if we do it on the map. Now, if I have to draw a parallel, if a layout is being made,
Is it Chintamani?
that is exactly the reason why I'm trying to state is that we need to say where Devanuru is. Devanuru is 2 hours distance from Mysore, if we take, say, Palace as the center point. If your lordship, there is a layout being developed, say, beyond Jigni, am I entitled to compensatory sites in Indranagar and choicest of ones and a sprinkling of all of them and 14 of them in Indranagar, I would not be entitled to. One of the defense taken earlier was that these are not incentive sites which have to be given in the very layout. They can be given anywhere, your lordship, because they're not incentive, they're compensatory. Compensation sites are always site for site. For example, if there's a flyover being made
That's right.
in the heart of town and they take my site, then they have to give it to me in the urban area and they can't compensate me with that. So if my area is being taken in Jayanagar, I can be given in Baswangudi or BTM equivalent value. I cannot be given something where I have own in Jigni and then I get in Indranagar. That is not possible. Your lordship, next. The allegation is that, your lordship, that there are a lot of sanctions that are languishing, not met the light of the day, and this has been done in a tearing hurry. Your lordship, all our brothers and sisters in the bar keep cursing us that we've taken up so much of your lordship's time over here for this matter. They can all say, where is the tearing hurry in this matter? This matter is not of any great importance. This matter could have waited. But your lordship, the point is ultimately,
I have granted an interim order. So that is the reason. It
I'm
should not-
just trying to say.
Are you
that
saying
this-
I should not take this?
No,
then?
exactly what, the contrary. I'm trying to state that they cannot say governor took this matter up while others are languishing.
You're drawing
So,
paraphrase.
drawing a parallel with what all my brothers and sisters have been cursing us with, but that cannot be done.
Oh,
It's the
are they so doing?
I'm sure they are, your lordship. So ultimately, it's the discretion of the governor. There could be other reasons for other matters, but that cannot be taken up now, right now to say that there are malifides in this and therefore it was taken up earlier. Your lordship, the rights of Dev,
ಬೇರೆ illustration ಕೊಟ್ಟಿದ್ರೆ ಚೆನ್ನಾಗಿದೆ.
this is,
Yes.
the pressure is on by all of the others, your lordship. The CM's wife, they're stating that others were also allotted. Your lordship, there is not one other case where allotment took
Is in
place
Vijayanagar.
in Vijayanagar area or any other well-developed area which is not in the heart of Mysore as opposed to being 2 hours away. Now, your lordship, even let's assume they're saying, okay, give us back our lands. 3 acres of lands worth 4 lakhs when it was sold. At best, it becomes 40 lakhs. Worst case, best case scenario, 3 crores. It does not go to up to 60 crores. That doesn't even happen in prime Bangalore area. And that could be the root of the ultimate problem. Your lordship, then also going into the aspect of many others, denotification. Your lordship, denotification can happen. There's land mafia everywhere. All of that denotification happens with whatever reasons. Can that be a reason that this, in terms of parity with other frauds, this cannot be excluded? It's ultimately a public servant. Your lordship, also with respect to the 262 and 264, your lordship, stating that 262, both in fact were owned by Ninga only. What happened was,
262?
462 and 464.
ಇದ್ಯಾವ್ದು ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಬಂದಿದೆ.
462 was also owned by the very same person, but he sold it to someone else. And this was what remaining for the 3 brothers ultimately. And flow of title doesn't happen. That's all.
Done?
Done, your lordship.
Yes.
Got the copy of the
Plan. Yes.
sanction plan. Cabinet colleague will show.
Sanction plan of that scheme,
The layout.
the
This-
layout.
This is the scheme
So,
that was
but
sanctioned.
where is this layout from? How far is this from Mysore? What Senior Counsel Lakshmangar said is correct? That it is 2 hours away from Mysore.
I don't know the details.
Must be from
Then we'll
Bangalore,
get
my
to
lord.
know. Huh?
Must be from Bangalore.
I shall put it on the Google map right away and show, and then Shashi would have to buy us all sites.
Must be from Bangalore.
Certified copy.
ಈಗ, there are 2
Yes.
aspects to be noted from the plan. One is this survey number along with 462, both are marked as denotified lands.
In
and
the
they-
plan.
In the plan. And when the survey numbers are mentioned as to the details of the project, these two survey numbers are not in.
ಅದ ಮಾರ್ಕ್ ಮಾಡಿ
ತೋರಿಸ್ಬಿಡಿ.
ಅಲ್ಲ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ ಸರ್, ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ. Oh, doesn't find a mention. Both 462 and 464?
Denotified ಅಂತಲೇ ತೋರಿಸಿದ್ದಾರೆ ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಕೊಡಿ.
So this is the layout plan that is executed and developed as.
ಇಡಿ ಮೇಡಮ್.
I'm now
2
instructed.
hours ಸ್ವಲ್ಪ.
ಅಲ್ಲ, I am now instructed to submit. Kesre is behind Columbia Asia in Mysore.
ಕೆಸರೆ ಗ್ರಾಮ. Then how can it be Devanur Badavane 2 hours from Mysore?
We checked both cases. We
Bangalore.
checked.
ಬೆಂಗಳೂರಿನಿಂದ ಅಂತ.
We'll see. We'll see, yes.
Hale Kesre is different. 40 kilometers, yes. What they are trying to put in is an Hale Kesru, which is near Columbia Asia. That's not the one. This is acquisition to us.
Anyway, Google will tell.
In the birds are,
Huh?
in the birds are creeping, chirping down.
ಯಾಕೆ ಹೋಗ್ಬೇಕು ಅಂತ.
Then I'll be the bellwether, your lordship will all.
Yes. Anybody else, sir?
The painstaking hearing.
No. Don't worry about that. I should determine that. That's all right. If anybody have to say something, please tell. Because I'm not going to list this again. Yes. ಯಾರ್ದು? ಕೊಡಿ. ನಿಮ್ದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
By tomorrow, your lordship.
By tomorrow it should be
Please,
there. Yes.
please.
ನಿಮ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ? ನಿಮ್ದು ಹಾಕಿದ್ದೀರಾ? ಅದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ ಅಲ್ವಾ? ಎಸ್ ಸರ್, ನಿಮ್ದು ಆಯ್ತಲ್ಲ? Everybody done?
Please.
I am also done.
We are deeply obliged.
Yes, sir.
Such a patient.
No, for today. I said DD done for the day.
Survey number is there.
Yes, thank you all.
My lords, if I can just make one mention, my lords.
6:00 ಕಾಯ್ತಾ
Date
ಇದ್ದೀರಾ?
was given for. I'm sorry, my lords. Date was given for tomorrow, my lords, but the office is not moving the matter, my lords. So instructions may kindly be given, my lords.
ಹೌದು madam. List
This is WP number 250.
Tomorrow, sir, 10:30 move ಮಾಡಿ, I'll take it at 2:30. List close ಆಗಿರುತ್ತೆ. How will you take it? Move it at 10:30
Please, my
tomorrow.
lords.
Vinod
Please,
Kumar,
it is already listed for today. my lords.
Serial number 52, my lord.
ಎಲ್ಲ ಇವತ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದ ಕೇಸ್ ಎಲ್ಲ ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗಿದೆ.
Oblige, man.
Bill number 61 is true, my lord.
ಹಾ,
Settlement, the time may be fixed, my lord. The respondent-
parties are there.
Yes, my lord, they're here right now. It was
Huh?
listed today.
ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ.
My lord, the urgency that I cited yesterday was, my lord, the respondents don't ordinarily reside in.
What's the
Bangalore.
offense?
Lord, motor vehicle accident case was 338 in 220.
Where the parties get them?
Please.
Yes, I'll finish that and leave. All of you can leave.
Great.
Yes. Parties are here,
Yes.
still waiting. Respondent ಯಾರು?
Respondents are the complainant and the victim, my lord. The petitioner is the accused.
True, sir. Respondents counsel ಇದರಾ?
Sorry to.
Sir,
Entry order continue.
that will, ಅದು you need not mention, sir. ಅದರಲ್ಲಿ heard reserved interim order subsisting will continue till the disposal of the petition.
For respondent number 2 and 3, for 2 and 3, my lords. May permit me to file.
What's the offense, sir?
My lords, the
Who said-
offense is 279 and 338 of IPC, my lords.
229 and
279 and
338.
Yes.
ಕೊಡಿ.
Lordship, may
Madam,
permit me
ಇದೆಲ್ಲ
to file
ತೆಗ್ದಿಡಿ.
ವಕಾಲತ್
Give it,
for
give it. Give the settlement,
Yes, my lords.
madam. Parties sign ಮಾಡಿಸ್ಕೊಂಡಿ sir.
Great.
Where are they from?
My lord, the accused victim is from West Bengal, my lord.
Oh, ask him to go. No problem. Order, you sign the order sheet and go.
Please.
Settled, closed.
Great,
But you'll get the order only after a week.
great.
Grateful.
Because they were waiting, I took it.
Grateful,
I'm
grateful,
grateful.
obliged. Cannot be supplemented by fresh reasons in the shape of affidavit or otherwise.
Of objections or otherwise.
Otherwise. Otherwise, an order bad in the beginning may,
Will get validated.
by the time it comes to the court, on account of a challenge, get validated by additional grounds.
The orders are not like old wine, getting better by the day. Yes.
Govardhan Das Banji, quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, not even by the contesting. Even if the officer gives it, it can't be accepted. Making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders publicly made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine, becoming better as they grow older. So that is what, so it has to be summarily rejected, whatever arguments or justifications are given. I'll come to the order later. Now kindly see, now that the court says there is a reference to it, may I take the court to the impugned order, volume 1 of the petition. Alla, ee kottidru.
Same. Volume 1 of the petition.
Volume 1 alli ಇದೆ.
Yes, sir.
Paragraph, page 41.
Yes.
Para 1 quotes the order.
Yes.
Para 2 quotes the two petitions given.
Para 3 show cause notice.
Para 3 show cause notice. Para 4
Committee.
council about the committee.
Yes.
Then para 5 the resolution of the
decision.
cabinet
Yes.
resolution. I have considered the decision of the cabinet dated 1/8. That is para 6. And file in relation to the issue at hand. It is noticed from the said file that Sri so and so had asked the chief secretary to convene a meeting of the cabinet and to place the show cause notice dated 26/7 and all other materials before the cabinet. Accordingly, the cabinet meeting was convened on 1/8/1918, wherein show cause notice dated 26/7 and other materials were discussed, and the aforesaid resolution dated 1/8/2024 came to be passed. I have also taken note of the fact that the said cabinet meeting was not presided over by Sri Siddaramaiah, the chief minister. So it only narrates what the cabinet has done. In the present case, the petitions have been filed seeking grant of sanction against Sri Siddaramaiah. The resolution dated 1/8 of the cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above, and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution against Sri Siddaramaiah, Chief Minister, I have also independently examined the petitions and documents submitted in support of the same, not the representation of the same.
Yes.
Now, since the sanction is sought against Chief Minister himself, the surrounding circumstances of placing the show cause notice and the decision of the cabinet would not inspire confidence to act on such advice. So it is about cabinet advice. Para 9. Subject of binding of the advice, again it quotes the cabinet this thing, and quotes Madhya Pradesh police establishment case. That is it. Then para 10, this is where a decision is taken.
Upon perusal of the material.
Upon perusal of the petition, sir, not material,
Petition along
Pet-
with the material.
along with materials in support of the allegations in the petition and subsequent reply of Siddaramaiah and advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It doesn't spell out what are those two versions. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of offences. Nearly 25 offences are cited. Which of those offences? For example, forgery is alleged. Is it the case that the governor is satisfied that chief minister has forged?
So this is the first question I asked him the other day. Anyway,
Yes.
he will answer.
Yeah. So, my very respectful submission, this is not consideration of the representation. And the, very interestingly, the note is important. That's why I was reading para 31 in the note. So this is all what the order says.
Order says, the governor's note is there.
Governor's note
Yes,
alle,
yes.
para 31 alle.
Yes, yes. You can read, yes, sir.
Yes.
Hmm.
In view of the averments made in the aforesaid petitions, seeking grant of sanction for prosecution and the materials in support of the same, subsequent issues of show cause notice dated 26, reply to the show cause notice of by Sri Siddaramaiah dated 3/8, legal opinion of the learned advocate general, and the decision of the council of ministers. I am of the opinion. So considering all this, what is the opinion formed? I am of the opinion that in exercise of my powers under Article 163(1), considering the aforesaid material placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion by independently examining the aforesaid material. So he now proceeds to examine. What does he examine? 31.1. It is seen from the resolution of the Council of Ministers. The conclusion has been arrived at by the Council of Ministers by non-consideration of relevant material facts. For instance, the Council of Ministers has taken into consideration that absence of possession notification or a measure taking possession was mandatory.
Yes.
However, the revenue transfer certificate as provided under Annexure A5 of the petition by T.J. Abraham clearly stated possession of the alleged land was with MUDA. Further, the fact that the alleged land was developed, etc., I'll come to it later. So, governor is satisfied, possession is with MUDA. Because Abraham says so, and cabinet advice to the contrary is rejected for that reason.
So documents are there.
I'm obliged.
His name is
I-
there everywhere.
I'm
That is what
deeply-
is said.
I'm deeply obliged for that. Kindly come to documents of Abraham.
R3 ಕೊಡಿ.
90 minutes governor has heard. I think this was the only pertinent question he should have asked. Kindly come to para 51.
Para 51.
Sorry, page 51. This is Abraham's petition. which sta-
Objections.
No, Abraham's application, sorry,
Complaint.
complaint, which starts at page annexure B, page 48.
Sorry.
I'm sorry. Garbudi aitu.
ಇಲ್ಲ, ಇಲ್ಲಿ file with. Page?
Page 48,
Yes.
annexure B.
No, you are referring to the complaint of T.J. Abraham.
Yes, R3.
That is found in which,
This is what the learned, I mean,
No, you're
The
reading the
index.
governor's note or the
No, governor's note refers to Abraham's
complaint?
complaint,
That is page 50.
page 48, annexure B.
48, it starts, annexure B.
Ah.
Yes, sir.
Yes. Now kindly come to page 51.
Hmm. Yes.
Award declared,
Hmm.
page 51. On 30th March 1998, subsequent to the notification dated 20th August 1997,
Ah.
the preliminary award notice dated 20th August 1997,
Hmm.
the award decision notice dated 12/3,
Hmm.
and the final award notice indicating award of 3,24,000
Hmm.
was issued on 33 to Ninga, son of Javra.
Hmm.
Sir, Ninga is dead
Hmm.
28 years ago.
But the award notice refers to Ninga.
It is issued in his name.
Yes.
It is issued in name.
Hmm.
A copy of the preliminary award notice, the award decision, etc., are produced.
Hmm.
Then immediately, next sentence, he stumbles on this conclusion. Possession with MUDA.
Hmm.
As a consequence of the notification, the entries for the year 98-99 in the RTC
Hmm.
indicates that the said lands were in the ownership and possession of MUDA,
Hmm.
effectuated by so and so. Now the question is, when was the possession taken over by MUDA? He doesn't say so. Why he doesn't say so, I will refer to it. Kindly come to annexure B1.
No, possession was taken over by Mood. No, he may say or is not said. But does the fact remain that possession was taken by MUDA after the preliminary notification, final notification, award notice, then MUDA is in possession. Everywhere it is said MUDA is in possession.
I am obliged.
Symbolic or
Kindly come.
physical.
I am obliged for that also.
Yes.
Kindly come to annexure B1.
That's the annexures that were read out earlier.
Sir, this has been suppressed. I'll point out.
What has been suppressed?
The fact that possession was not taken.
Where is the document?
I'll show that. Kindly come to annexure B3.
D3,
B3,
B3.
page 105. This is the crucial document. I request the court to kindly permit me to read.
Yes,
It's a very
yes.
short document.
Yes, yes. Award notice.
This is award notice
Yes,
under section 12(2)
yes,
of the Land Acquisition Act.
yes.
So everything is addressed. Ninga, as
Ninga.
court observed, it
Yes.
is Ninga Uruf Javra.
Hmm.
Property name is correctly described.
Hmm.
No problem. Kindly come to the narrative at the bottom of the page. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಅವಾರ್ಡ್ ಆಗಿರುವ 3,24,700 ರೂಪಾಯಿ ನೀವು ಈ ಆಫೀಸಿಗೆ 15/4/98 ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ ಈ ಜಮೀನಿನ ದಾಖಲಾತಿಗಳ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿರತಕ್ಕ ದಾಖಲಾತಿಗಳು ಹಾಗೂ ಈ ಸ್ವತ್ತಿನ ತಹಲ್ವರೆಗಿನ 13 ವರ್ಷದ ಬಾಬ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮೇತ ಹಾಜರಾಗಿ ಮೊಬಲಗು ಪಡೆಯತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಪ್ರಾಧಿಕಾರದ ಕೆಲಸಗಳಿಗೆ ಬೇಕಾಗಿರುವುದರಿಂದ ಅದನ್ನು ಈ ನೋಟಿಸು ತಲುಪಿದ ಡ್ಯಾಶ್ ದಿನದೊಳಗಾಗಿ ಅದು ಕೂಡಲೇ ಇರಬೇಕು. ಐ ಡೋಂಟ್ ಗೆಟ್ ದಿ ಇಟ್ ಇಸ್
ತಲುಪಿದ ಕೂಡಲೇನೆ.
ಕೂಡಲೇ ಇರಬೇಕು.
ಎಸ್.
ಕೂಡಲೇ ದಿನದೊಳಗಾಗಿ ಖುಲಾಸು ಮಾಡಿ ಇಲಾಖೆ ಮಜುಕೂರಿಗೆ ಒಪ್ಪಿಸಿಕೊಡತಕ್ಕದ್ದು. ವೆಕೇಟ್ ಮಾಡಿ ಪೊಸೆಷನ್ ಸರೆಂಡರ್ ಮಾಡಿ ಅಂತ. ತಪ್ಪಿದಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಕಾಯ್ದೆ 16ನೇ ಸೆಕ್ಷನ್ ಮೇಲೆ ಸ್ವತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. ಸೊ ದಿಸ್ ಈಸ್ ದಿ ನೋಟಿಸ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹಿಮ್ ಟು ಸರೆಂಡರ್ ಪೊಸೆಷನ್. ಅಲ್ಲದೆ ಇತ್ತೀಚಿನ 3 ವರ್ಷಗಳ ಎಟ್ಸೆಟ್ರಾ ಅದೇನು ಬೇಡ. ಸೊ you surrender possession immediately. When was this served and on whom it was served? It was served on one son, Mallayya. It was served on 18/4/1998. 15/4 ಬಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಅಂತ ಕೊಡೋ ನೋಟಿಸು 18/4 ತಲುಪುತ್ತೆ.
4 days ಅಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅದೇ ಆ ಇವೆಂಟ್ ಆಗೋದ್ಮೇಲೆ, ಆ ಡೇಟ್ ಆಗೋದ್ಮೇಲೆ ತಲುಪುತ್ತೆ.
ಹಾಗೆ.
ಸೊ ಅವ್ನು ದುಡ್ಡು ತಕೊಳ್ಳೋದ್ ಸ್ಕೋಪ್ ಇರ್ಲಿಲ್ಲ 18/4. ಸೊ ಅವನು ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾನೆ ನಿಂಗ ಪಾವತಿ ಆಗಿರೋದ್ರಿಂದ ನಾ ತಗೊಳ್ತೇನೆ ಅಂತ. ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ಅದು before he was dispossessed, either he should have surrendered thereafter and there should have been a measure. Not a scrap of paper is produced by them to say that any such measure was conducted or possession was taken. Much less any details are given as to when and where, by whom possession was taken over. Now, after the award notice, immediately within a month thereafter, denotification happens. That is at page 110,
Yes.
18/5.
18/5/1998.
Yes. It is gested on 4/6.
Page.
Page 110, Annexure C. ಇವತ್ತು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಇದೆ ಅದು. ಅಲ್ಲ, ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೂ
ಎಲ್ಲೋ ಇದೆ. Those
ಅದ್ರ-
documents have.
ಹಾ.
It's a compilation of all.
ಎನಿವೆ, ಇದು ದಿಸ್ ಇಸ್ ಡಿನೋಟಿಫೈಡ್ 464 ಕನ್ನಡದಲ್ಲಿದೆ. ಕನ್ನಡ ಅಂಕಿಗಳು ಪೇಜ್ 111.
The government takes a decision to denotify?
Yes.
Yes. All right, government order. Notification.
Yes, government notification, and it's a gazette notification. And it is pursuant to the deliberations of the committee, which my learned friend Dr. Singhvi has already highlighted. Now, very important to take note here is that after the denotification, no further development has taken place. Possession was either asked or pursued after the denotification. Obviously,
But layout is formed, everything is done.
ತಾವು ಹೇಳ್ತೇನೆ ಒಂದು ನಿಮಿಷ.
ಅಲ್ಲ, no development has
acquisition
taken
act.
place.
ಅಲ್ಲಲ್ಲ, ಒಂದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್, ಒಂದ್ ನಿಮಿಷ ತಾವು ನೋಡಿದ್ರೆ